رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. Dear respected brothers and sisters, Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you for attending this today's Islamic World Workshop. We'll begin inshallah with a recitation from the Holy Quran by Sheikh Abdel-Hadi.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. هو الله الذي لا إله إلا هو عالم الغيب والشهادة هو الرحمن الرحيم. هو الله الذي لا إله إلا هو الملك القدوس السلام المؤمن المهيمن العزيز الجبار المتكبر سبحان الله عما يشركون. هو الله الخالق البارئ المصور له الأسماء الحسنى يسبح له ما في السماوات والأرض وهو العزيز الحكيم. صدق الله العظيم.
Jazakallah khair, Sheikh Abdel-Hadi. Before we begin our session, a few quick disclaimers. One thing, today's event is being recorded, as you probably know, so by attending, you consent to the recording. And another one disclaimer is basically, this is an educational seminar for informational purposes only. It does not constitute legal advice or legal representation whatsoever. The format will basically be, inshallah, our speakers, honorable speakers will speak within their expertise, inshallah, and then followed by, I'll quickly browse through the will, just to kind of give you an idea what it is and what you might need to do, followed by Q&A session, inshallah. If you have any questions, we'll take some questions. Having said that, it is my honor and privilege to introduce to you the speakers of today's workshop. Brother Ijaz Sabir. Ijaz Sabir is an attorney by profession and the greater Philadelphia area. Mr. Sabir has over 15 years of experience in various roles, including a legal advisor, public speaker, and founding member of Sabir Law Group. He has represented clients from over 70 different countries. Mr. Sabir is the first attorney from northern India, Kashmir, to concurrently serve as an advisor on Asian affairs to leaders of City of Philadelphia Mayor, District Attorney, and Police Commissioner. He has also served as a member of Asian Pacific American Bar Association of Pennsylvania, National Association of Muslim Lawyers, Council on American Islamic Relations, and Amnesty International. Mr. Sabir is an active member of several interfaith organizations. He speaks to clarify misconceptions about Islam, civic engagements, and immigrant rights, and has been involved in interfaith programs in over 30 establishments in the tri-state area. MashaAllah, Mr. Sabir has received certificates and awards from different organizations for his professional and social contributions, which include Channel 6 ABC Outstanding Community Service Award, Philadelphia Mayoral Commission on Asian Affairs, Christian League of Pakistan and America, Philadelphia Sikh Society of Delaware Valley, Pakistan Community Cultural Organization, Philadelphia Police Commission on Asian Affairs, Philadelphia District Attorney Commission on Asian Affairs, and successful Asian Career Institute of Abdel-Hadi. Brother Ijaz is a graduate of Temple University and earned his Juris Doctorate degree in 2 years from Western Michigan University. He lives in Town with his wife, their son Abdullah, daughters Fatima and Aisha, and a cat called Merlin. Merlin? Mashallah. Our next speaker, guest Cyril Papadi. Mr. Papadi has been a dynamic register of wills, having first been elected in 2010 under his leadership. The office launched an innovative program which has audited over 150 million in unaccounted assets, netting some 2.4 million in new revenue for the New Castle County. Cyril has also released Delaware State Administration, a how-to manual which, for the first time, unifies statewide policy on what happens when someone dies. The result of Delaware State Administration has been to protect seniors by streamlining the probate process. For his efforts, Cyril was awarded in 2015 Government Service Award for the Delaware Bar Association. Cyril was born and raised in Wilmington. He's a graduate of Celestinium School, sorry for the mispronunciation, Princeton University, Delaware Law School, and Army Law School. He's a member of the Delaware Bar. Cyril serves as a judge advocate, and the Delaware Army National Guard. Cyril is an adjunct professor at Wilmington University teaching law, government philosophy, and history. He writes frequently and has written a regular column for several publications over the years. So, last but not the least, our beloved Sheikh Abdel-Hadi, mashallah, he needs no introduction, everybody knows him very well. So with that said, our first speaker will be Brother Ijaz. Inshallah, he will brief us on his expertise.
Assalamu alaikum and good morning. I thank Allah subhanahu wa ta'ala for giving us wisdom, vision, and strength to be here. I thank you all for attending. Thank my esteemed panelists for joining this morning. And thank you, Brother Shafiq, for providing this opportunity to stand here and share this beautiful morning. It's pretty rough thing to hear about your introduction. I didn't know that you were going to use it for that purpose. I told you earlier that we just mentioned it, was good enough, but thank you so much for reading the entire introduction. Today we'll inshallah briefly talk about, I will personally talk about three main documents, and Mr. Papadi will go in detail. I apologize if I mispronounced your name, but he'll go into detail. As you heard earlier, I'm a practicing attorney in Pennsylvania, so if you have any issue related to Pennsylvania, feel free to ask me. But outside Pennsylvania, I am only licensed to advise about federal matter, which is immigration law. So if you have a question about immigration law, feel free. I'm licensed in all 50 states. But as for beside immigration, I'm only licensed in Pennsylvania, so whatever you have related to Pennsylvania, you can ask me. With that caveat and disclosure, there are three documents that we'll talk about. They are very important documents. They're important documents in your life. They not only affect you, but they affect your family after your demise and your death. The three documents I will mention briefly, and we will go into detail. Power of attorney, living will or health directive, and the third document is will. Power of attorney, what is that? Let's use a scenario. If you're in an accident, and you didn't have a major accident, but it's a minor accident, you broke your leg. And you're immobile, you're not able to travel, you're not able to go anywhere, you're bed resting in a hospital at home, but you have to pay your bills. Welcome to corporate America. So how do you manage? So you have to designate somebody else to act on your behalf. It's called power of attorney, and many people from sub-continent India, Pakistan, Bangladesh familiar with it as an authority letter. But here in America we call it power of attorney. So you give authority to somebody else to act on your behalf. The power of attorney can be specific. For you can tell somebody just sell my property, collect rent, or you can ask them to just take the money out of my bank, pay my bills, or specifically that I go to the passport agency to pick up my passport. So certain specific need basis, or you can have a general durable power of attorney, which means pretty much they can do anything and everything. In Pennsylvania, I advise my client always to have power of attorney and vice versa, from husband to wife, wife to husband, because sometimes you're traveling abroad, you're stuck somewhere, again, immigration instinct, so you need to have access to get the documents and things in order. So that's called power of attorney. Let's assume that your accident was not, minor, it was a major accident, and you went into a coma. So now it's time to make a decision about your health. So that's why it's called health directive, and also alternatively used as living will. You are living, but you're living on a ventilator, you're not dead yet, but you're unconscious, you're in coma. So now the doctors have to make a decision what to do with your medical needs. And at that very moment, let's assume that you can just wake up for 1 second and can tell doctor what to do. That option is available now to write a living will. Tell doctor that you want to live on a ventilator, you want to put a plug, you want to die. What is your wish, how you want to be treated in the last stage of your life? Do you want to stay on a ventilator for a long time? Do you want to be a brain dead, and that considered as dead? Those are the things that you need to make medical decisions now. At that stage, you're unconscious, and family is distraught. They cannot make a decision. They don't know. They don't have medical ability to make a decision. But you need to dictate about your body, how and what to be done at that very stage. Assuming that your accident is worse, and now you're dead, then the third document is coming to picture, it's called will. And that's the most important documents. Again, all of them are important, but by this time you're gone. And I was joking earlier with my colleague here, Mr. Abdel-Hadi, that people come to my office, I do general practice, I do pretty much everything. And when it comes to probate law, which means when you die, and after that, how the assets should be distributed, that's where his department is in your New Castle County. So I was joking with him, so I'm having issue with dealing with alive people. How do you deal with dead people? So it is a problem. It is a massive problem if you don't have a will. In that will, you write it down who's going to get what asset, how should be distributed, major safety deposit account, who's going to manage passwords, organ donation, anything that you have to address, you can write in that document, and that makes the life very easy for the people who are left behind in your family. What you write, how you write, you can consult local attorney as for Islamic aspect. I'm not going to get into it. Thank God we have a scholar here. There are differences of opinion among it, and he will address that stuff. So I'll leave it up to him. But you need to have those 3 documents hanging. And I would strongly suggest that make sure you put an effort to do it. I'm not familiar with Delaware law. In Pennsylvania, you can have holographic will, which means you can have handwritten will for time being. I usually do a lot of project with CARE. Again, I thank CARE for providing the opportunity to come here as well, but I do Pennsylvania project with CARE. So we advise people for time being, write the documents now, so God forbid if you die today, so you have something. So then you can go back and calculate your assets, you don't need your families, you don't need your siblings, because under Islamic law, it's not only what your wife is getting, and your children are getting, its extended family is part of that as well. So you sit down and make a long will and long detail with your lawyers, but for time being in the seminar, you usually advise people to have a holographic will handwritten, because God forbid if you die at conscience, we have something. And if you do not have a will, then there are a lot of consequences. I don't want to get into those because that's part of Mr. Abdel-Hadi's speech. So there's again those 3 documents that we will go in detail. There are other documents besides those 3. You'll probably Google it and you'll probably hear about it. Trust, irrevocable trust, revocable trust, remanders, a lot of other things. But again, those are in depth, in detail. You should sit down with an attorney and they can advise you based on your need. But right now for today's seminar, today's program, we'll just discuss those 3 documents. In will, you can also assign. If your children are minor, who's going to be guardian, who's going to be personal representative? At the age of 18, if you have a property, a house, who's going to sell it? Who's going to make the decisions, college, school? All those things can be stipulated in the will. So this is again the document that will come into picture after your death and demise. There are religious benefit, obviously, again, you have to have documents, but the legal benefit I'm focusing is I don't have a word to emphasize. You have to have will. I'm not getting any money out of your will if you write here, because I'm not licensed to write your will here, but I would strongly suggest that you should write it as soon as possible. I'm not sure what holographic will is allowed in Delaware. Well, I'll leave it up to you.
You need two witnesses.
2 witnesses?
Must be 2 witnesses.
Okay, great. So again, you can write your own will and you can have 2 witnesses. So, so that obviously we'll go into detail about that. My point is that these are important documents. Get them done as soon as possible. Again, thank you so much for the opportunity, and we look forward to answering your question. Answering question, I normally mention that if you're asking a question, please go ahead and ask whatever you have in your mind, because we want to have open discussion. If I don't know the answer, after 15 years of experience, I'll try to find an answer for you, and I'll try to drive you in the right directions. But when you're asking a question, please do not say, I have this problem, what do you think? My answer will be, let's consult in confidentiality, and let's meet in office, and let's meet in another room. Because once you say it's my problem, as an attorney under ethical rules, I cannot advise you, because we should be discussing individual problem in front of everybody. So you can hypothesize your question, saying, what happened, if that happened, that happened, that can be your own problem. But the moment you say, I have this problem, what do you think? Then I will be able to accept the under ethical rule. So,
Can you say one more time those three elements?
3 documents?
Yes.
Number 1 is power of attorney. You are alive, you're conscious, but you're immobile. You cannot move around, so you can get somebody else to act on your behalf. Power of attorney. Number 2 is known as living will, also known as health directive. Again, you're alive. That's why it's called living will, it's not will. Living will, you're alive, but you're in coma. So health directive, so somebody making a decision about your health state, last stage of your life. And the third document is the will itself. By this time, you're dead, you're underground. Already?
All 3 documents in here.
I'm sorry?
All 3 documents in here.
I didn't have a chance to review these documents. Again, I'll get back. Thank you so much for your time. We'll talk about this in question and answer session. Thank you. Sorry.
Jazakallah khair, Brother Ijaz, great information. Hold on to your questions. If we didn't get the answers to you during the speaker sessions, then we'll have a Q&A session, and they will also actually review this document. We just go quickly browse through it, just kind of get an idea. By the way, 2 out of the 3 documents are actually in here. So health proxy is in here. It's just a 1-page document, it's brief to the point. And the living will, which is health proxy, and the actual will. So those 2 documents are part of that. And also, I forgot to mention, today's session actually is administered by the Islamic Delaware Education Committee. It's co-sponsored by CARE Philadelphia. They always help us with providing us great support. We thank them for their services and their support. With that said, I request Mr. Papani to speak. Thank you so much.
Thank you. Well, first of all, I want to say not only good morning to everyone, but thank you. Thank you very much for having me. And I say a special thank you because I was here almost exactly 2 years ago. It was a Saturday in August, and I have to say thank you because there were so many blessings that came upon me in the hours and the week afterward for being in this holy place. So I come again today joyfully because I experienced the grace of having been here. So I say thank you. I also say thank you to, and I love the word you used, our beloved Imam, right? I say thank you for welcoming me. There's very few religious leaders in Delaware that would let me sit at their left hand. So you have a special place in my heart. And
Can I add one more thing for
sure.
the importance of today?
Yes.
It is a unique day when 29,800 something, around 30,000 people are getting married because of this day. Wow. Which is, 18. Oh, right, okay. So it's a, nice coincidence what we're talking about. Yes.
I'm not getting married today. But that's great.
I am going to wedding today.
You're going to wedding today. Can you bring me? And I say thank you to Mr. Sabir for coming today and Mr. Sabir is modest, but in addition to his remarks today, he has an important practice in the immigration field. And I am a lawyer here in Delaware, and I can tell you there are only a handful of immigration lawyers in Delaware, and most take very rudimentary, very simple cases. And in the area of immigration law, you can get an attorney in any state. It doesn't have to be in your home state. In fact, I know many Delawareans who not only who need immigration help or help for a friend, a neighbor, a family member, and they will reach out to attorneys in Texas or Florida or California or New York. So it's great that we have someone of his expertise locally. So remember that, right? Yes, definitely. Okay, so I know that there's an issue with my name. I get it. In fact, when I call folks and I say zero property on the line, they say, is that zero properties? So, this is who I am. I have the honor of being the Register of Wills here in Newcastle County. The Register of Wills is the judge, okay, who oversees what happens when someone dies in Newcastle County. So today I'm going to give you the judge, or better put, bureaucrat, the government official's view of this whole topic, which is estate planning, okay? And I'm going to touch on that for those who may not know what's an estate, okay? And our theme today, as we've heard already, is taking control. You have a great opportunity on this 8-18-18. You have a great opportunity to take control now, so that when troubles come, when there's a crisis, there will not be a crisis. You know, one of the things that I see so much as the Register of Wills is obviously I see individuals in crisis. They come to my office when a beloved family member has died. And I'm sure we've all gone through having death in our family. And we all know that everyone, every human being, even me, even my family, the wealthiest families, the most powerful, and the lowest, the poorest families, all go through grieving. It's about being human. And you go through denial, you go through bargaining, right? And you go through anger. And I see a lot of individuals who have a death in their family, and they're in the anger phase, and they're not coming out of that anger phase for a long time. And why I'm mentioning this is when you prepare, when you take control now, you are alleviating your family members of much of the grieving process. Because instead of arguing with each other over burial, over the division of property, over so many things that happens when one dies, instead of arguing about all those things, you've paved the way. You have established what you want to happen. And so instead of arguing, they can grieve together and get beyond anger towards resolution. I see so many families that when they have the death of a parent, there's so much anger that they're never going to have another holiday meal together. It becomes the ruin of the family. Do not let that happen to your family. Take control now so that when death comes, your family is going to stay together for many more generations. Okay? And you take one message today, it's that. Take control now. Okay. What is just so before we get into a review of some of these documents, what's an estate? What's probate? Have you heard the term probate? Okay. An estate here in Delaware is what you have when you die. So if I die today, I have a home, I have some bank accounts, I have some stocks and bonds, right? That, I have personal things, my clothing and such, furniture, computer. That's called my estate, okay? That's all the things that you have when you die. And then the legal process that is going through the Register of Wills, and I'm a part of Chancery Court here in Delaware, which is a famous court. The process of going through the Register of Wills and Chancery Court, that legal process is called probate. So when you're in probate, you're in the midst of the legal process to have your estate verify what did Ciro own, and then to have it dispersed to the correct heirs. Okay, so that's an estate, what you own, and probate is the legal process. All right. So someone asked, and what we're keying on, and Mr. Sabir did a beautiful job, what we're keying on today is 3 documents. You heard power of attorney, you heard advanced health care directive, and you heard, of course, your last will and testament. And this document that has been dispersed today has 2 of the 3, and that's good. There's a good reason for that, okay? The 2 that you must have are an advanced health care directive, and sometimes, as Mr. Sabir mentioned, in the media, because the media only operates in headlines, right, in little tweets, if you will. They call it a living will. But at law, when we talk about this document, we call it an advanced health care directive. I'll explain why. And then a will. So what has been distributed today has the 2 key documents, an advanced health care directive and a last will and testament. That's a good thing. I'm going to talk in a moment about powers of attorney, and you may or may not need a power of attorney. You may or may not. You may need one, you may not need one. So that's one that's not included because individually you have to see your situation. But what you definitely need are an advanced health care directive and a last will and testament. Okay. Let's talk about power of attorney here in Delaware. And I'm going to put it in context of our discussion of estate planning. So a power of attorney is while you're alive. And that's the key concept. A power of attorney is while you're alive. When you pass, when you die, a power of attorney passes as well. It's only effective while you're alive. And why that's important, ladies and gentlemen, is because so many people come down to my office and say, I want to take charge. I want to be the executor of Aunt Sue's estate. Aunt Sue has died and I want to be the executor. And I ask the person, okay, under what authority? Did Aunt Sue have a will? No. But Ciro, I'm her power of attorney. Well, it doesn't work that way. When Aunt Sue died, what happened to her power of attorney? It died too. And the reason I mention that is that so many people think they don't need a will. So many people think they don't need a will because they have a power of attorney. And it doesn't work that way. A power of attorney is while you're alive. And then what takes over when you die is your will or lack thereof. Power of attorney while you're alive, and then when you die, it's your will that takes over or lack thereof. I mentioned earlier that you may or may not need a power of attorney. That's right. A power of attorney is for your specific circumstances, okay? And what a power does is it allows someone to step into your shoes, and make financial decisions for you. Step into your shoes and make financial decisions for you. And not everyone needs that today. And before you make a power of attorney, be sure to get legal advice, because not everyone needs one. Be sure to get legal advice. I'll give you mine, and too much of this discussion I'll talk about me, so excuse that. But in my situation, I'm married and I have 2 teenagers. In fact, that's why I like coming today, because in my home, no one listens to me. Here I have a captive audience. That's so unusual. All right? In case something happens to me and my wife, because we have 2 teenagers, let's say that we are in a car accident together, right? And that happens, right? Go out on 95 or 495, you see these accidents. If my wife and I are in a car accident together, and still living, but maybe in the hospital, we need someone who can continue to pay the bills and look after the finances for the children. And so we need one because our children are small. In our circumstance, we need one, we have one. Your circumstance may be different. You should not make a power of attorney without having legal advice, a lawyer, financial planner who can look at your situation and see if you need one. Fair enough? Okay.
When would you not need it?
When would you not need it? Well, there are circumstances where, like for example, if I'm married and my children are now grown, right? My wife at law can speak for me. Okay, so if you came to me and you were married and didn't have children, or your children are grown, I may say, listen, you're okay for now. Something should happen to you, your wife can speak for you and vice versa, and you may not need a power of attorney in that situation. Or, and this is, I'm giving you class 101, this is really the advanced course, okay? We would make the power of attorney spring forward, so that right now, if something happened to you, sir, your wife would speak for you. But if something happened to both of you, then it would spring forward and maybe an adult child or maybe a family member could speak for you in finances. All right? So the underlying thesis here, the underlying point is don't make one without seeing an attorney, because we have to be very careful what powers and when do they spring forward, or are they effective now, and who is going to have that power. Fair enough?
Because at that time, as you said,
Yeah.
then the will will be operated.
When you pass, the will would, okay? Up until that point, the power would be effective. And once you make one, it's difficult to unravel it. Once you make a power of attorney, it's difficult to unravel. So that's why you have to see an attorney as to when it's effective, will it be present or spring forward, and who will be that person while you're alive. Okay? Yes, one more.
Does the judge decide when the power of attorney is effective?
Say this again?
Who decides when the power of attorney becomes in action? How does that?
In action? Okay, so like if it springs forward?
No. If something happens to you, and who decides if you're unable to act on your own?
Oh, good question. Okay. So how does a power of attorney become effective in the sense of, my wife and I are in a car accident, right? We're in the hospital. How does my brother, who's our agent, actually take authority over it? Okay? And what a power of attorney generally says, and again, this is why we want you to see an attorney, and I'm not all about always having to have an attorney, okay? But for this, definitely. What the power of attorney will generally say is that if my family physician writes down that I no longer have the ability to manage my finances, my brother will take over, okay? And so, hold it, Ciro, aren't doctors gonna, are doctors, that's fraud. My doctor might put that and I will lose control over my finances. Well, the reality is doctors have license too, and they are very scared to write down for you to lose power, or in my example, for my brother to take over, unless it's very, very true, because they don't want to get in trouble themselves, they don't want to put their license in liability. So the power of attorney generally has language about if my doctor, my family physician or physician says that I no longer have that ability, then it will spring forward to that family.
Is it for a limited time?
It is. You folks are so curious about the power of attorney. That's the last thing I wanted to talk about today. You know why? Because this is not a self-help. The power of attorney is not a self-help. It's one that you need to sit down in a quiet hour with an attorney and go over. All right? So I'll take this question and that question, and then we got to move on, because now you're all thinking, I can take out my own appendix. No, you cannot take out your own appendix. You must see legal counsel. But your question is what?
The doctor writes something at your situation.
Yes.
It is honest truth.
Yes.
That I cannot make those decisions. But after 5 days, 7 days, I am able to.
Okay, so what happens when you come back? That's right. Okay, I'll get that to it. And yes, ma'am?
Yes, so I just want to be very clear.
Yes.
If I have assets that are not jointly owned with my spouse,
Yes.
and if I am not able to make a decision, does my spouse automatically have power of attorney, or do I have to specify? Only in cases when the assets are not jointly owned.
Okay, great. So let's take that first. What happens if I don't have a power of attorney? Okay, how does the law work here in Delaware? And then your question is, if you are disabled, in other words, you cannot make those financial decisions for yourself, how about what happens when you become able again? Okay? All right, so in the first question, if you do not have a power of attorney, generally your spouse can speak for you here in Delaware, okay? And so if you didn't have something in place and something happened to you, generally your spouse can make decisions for you. However, banks think they're lawyers, and lawyers think they're bankers. Okay? So when you speak with your attorney about putting this in place, they will be very specific to make sure that your spouse has total control, and then if something should happen to your spouse, generally it springs forward to another person. Okay? But if there wasn't anything today, generally your spouse can speak for you. Okay?
Just a
Yes.
quick reminder to everybody, if they can write their questions and wait till the Q&A.
Okay, fair enough. I'm like the Socratic method. I like to, yes, no, that's, all right. So, on your question, what happens if you become able again? When you become able again, then, in theory, you notify your agent then notify the bank and etc. that I'm better again and I'm taking back control of my assets, okay? And this is why we need to have legal input, because we need to make sure the person that you choose is going to cooperate with you as you take back control of your assets.
If there is any asset by that point.
Yes. Follow that? Okay. All right. At this point, good questions. I want to have a ding, ding, ding moment. Very important concept here today, which is when I talk about powers of attorney, I talk about finances. And when we talk about finances, we must cover insurance. The biggest issue that I see as the Register of Wills involves insurance. So if you have insurance, please, this week, everybody in the room, go out and double check that your insurance has your beneficiaries properly named. Because so often I see insurance that there is no beneficiary, or the beneficiaries have predeceased, or they're not properly named. Okay? What do I mean by this? Well, let's go. What is insurance? Insurance is where, right, I pay a insurance company, it's a private contract, and I pay them a yearly premium or a monthly premium, right? Do we have insurance? Various insurance policies, right? And if I die, today's your lucky day. When I die, you're going to get $100,000. Fair enough, right? You're my beneficiary. And so when I pass, you bring the death certificate to the insurance company, and they write you a check for for 100,000. And guess what? Here in Delaware, and in general terms nationally, that 100,000 that you just received is tax-free. We like tax-free, do we not? Yes. So it goes to the person that I wish, and it's tax-free. If I do not name someone on the insurance, and that happens, or if the person predeceased or if it's a confused name, and it's a wrong name on there, then instead of issuing it to you, they will issue it to the estate. They will write to the estate of seropopity. And the problem with that is that instead of going to you directly, it will come over to this pot in front of, in probate, in the Register of Wills. And now two things happen. Number one, it becomes all subject to tax. Instead of being tax-free, it's all subject to tax. That is a heart attack moment, right? And the second thing, instead of going into the family member or to the organization that we wanted to go to, okay? It comes over here, and now it may not get to the person or the organization that you want to get it to. So double check, because insurance companies are run by people. People make mistakes. Okay? Despite all the technology out there are mistakes. And I can just share a story with you. Before I became the register, I practiced estate law, had a beloved friend, a World War II veteran. I got a person of great means. I got all of his estate planning done to the penny. When he passed, he had virtually no taxes. The probate process was very easy. It went to exactly who he wanted to. He made charitable gifts, and eureka. We discovered, he didn't tell me, maybe he even forgot, that through his military service, he had a $100,000 insurance policy. And guess what? It had no beneficiary. I didn't know about it. Maybe he even forgot. We found it after he passed, and as a result, instead of going to his daughter, who he really wanted it to go to, given his other estate planning, I know exactly he would have named it to his daughter. It came into probate. It was all subject to tax. It triggered other taxes because now his thresholds had gone over despite all my planning, and it became a mess when it didn't have to be a mess. So please go out and double check insurance. If you have retirement plans that are payable on death, any insurance is payable on death. Anything that may be payable on death, double check your beneficiaries. And every 5 to 10 years, double check them as well. Okay? And when I mentioned insurance, I also talk a little bit about my own situation, whereas I'm not a wealthy person. I'm a government bureaucrat. I make a nice living, but I'm not extremely wealthy. However, through my service with the Army, I am able to buy a lot of insurance. And the reason that I mention this is that when I pass, many years from now, hopefully, my estate is going to be wealthy. Today I'm taking a lot of insurance, and again, this is my example, I'm taking a lot of insurance because should something happen to me, now I have money in place for my wife and my children to help get them through college, marriage, and up and running, okay? But eventually, heaven willing, my children will grow and they're going to be fine. My wife and I will go into old age, and when we die, we're still going to have these, if I can say, robust insurance policies. And our plan is not to leave these insurance policies to our children. They're going to be okay. Our plan is to lead them to various organizations, including our church. Because I may not be able to give my church, and we're also very involved with Faithful Friends, and we're also very involved with various cultural organizations. I can't give my church, Faithful Friends, my cultural organizations, $1 million today, but the day that I die, I will be able to. So I just put that out there, that all of you have the potential to make large gifts when you pass through insurance or payable on deaths. I'm not telling you to do that, obviously. I'm just opening your eyes because my wife and I have chosen that path where we can make a difference when we do pass. Insurance is in place for our family now. Eventually, down the road, if the plan goes well, they'll be okay, and then we can make a difference in the organizations that we feel strongly about. Fair enough? All right. You like that plan, don't you, Mr. Sabir?
Love it.
Yes.
Only thing I need to be beneficiary on the policy.
Okay. An advanced healthcare directive is, again, while you're alive. It's in place while you're alive. And why is that, while you're alive? Mr. Sabir? Because when you're dead, you don't need healthcare. Am I right? Okay. So it's while you're alive, you're naming an agent who can stand in your shoes and make decisions for you. Okay? And the lovely packet that you have today does include essentially this advanced healthcare directive. It says healthcare proxy and living will. Yeah? And so this document is here, and guess what? I was all about getting an attorney for a power of attorney, right? You got to see a legal counsel. This, you do not. It's right here. And the lawyers in the state of Delaware, through our Bar Association, Lawyers Association, have made it, especially our section, which is elder law, estates, and trusts, have made it a priority to preach to everyone that everyone needs an advanced healthcare directive, some type of proxy. Because the reality is that given the number of nice people we have here today, the reality is that all of us are going to live through the next 6 months. But 2 of us are going to need to go to the hospital. And 1 of us, statistically speaking, in the next 6 months, is going to go to the hospital unconscious. And so if you go to the hospital unconscious, you need to have a document in place, right, for someone to speak to you. Now generally, spouses here in Delaware can speak for each other. And generally, parents can speak for minor children that they're the guardian of. Okay? But if you're in the emergency room, unconscious, the hospital aren't gods. They don't know who your spouse is. They don't know who in the family can speak for you. You need to make this, you need to execute this document. Give it to your agent and make sure your agent is comfortable in being able to speak for you and make the decisions in line with your faith and with your faith-based feelings. Okay? And I always encourage everyone that obviously your spouse, that's a natural one that will speak for you. But when you think of an alternate, okay, in case, again, you and the spouse are in an accident together, when you think of an alternate, think of someone local. I know that we have trusted friends in, let's say, Vermont, or let's say Georgia. We have a family member who lives in Texas and such. But if a beloved family member that you trust is living in Texas, and you go to Christiana Hospital, are they going to drop everything in Texas to come up here? They're not. You follow that, right? So name someone local. My wife and I, have named Cousin Peggy. Who can speak for me immediately, of course, is my wife, and she has a copy, and I have a copy, so we have copies. But we also asked if something should happen to both of us, Cousin Peggy. Cousin Peggy said yes, and she has a copy of our documents, so that if something happens to us, she can run down. She lives locally, in fact, she lives 2 blocks away from us. But Cousin Peggy is also a nurse. In fact, she works on kidneys, and she skips from Christiana to the VA hospital, St. Francis, to Bay Health. So everyone knows Cousin Peggy. Now, the reason we picked Cousin Peggy, not only is she local, not only will she follow our wishes, but she speaks the medical lingo. And so I just throw that out to you. After a spouse, is there a trusted family member who lives local? And is it a plus if they are in the medical profession where they could be speaking with nurses and doctors on your behalf? Okay? Advanced Healthcare Directive, you're right now taking control to name someone who can speak in your place on healthcare, and you don't need a lawyer. There's a beautiful document in this packet, and everyone needs to have that in place. Fair enough, gang? Okay.
Is there a question?
Yes. Yes, ma'am.
So you did talk about the spouse would generally be able to speak on your behalf.
Yes.
But what if I name a person in this document that is not my spouse? And can we be in a situation where those two get into an argument while I'm incapacitated?
So, if you name someone who's not your spouse in the document as the primary person, you're taking control now, and you're naming that person. At law, that person is the only one who can speak for you. So, that's the beauty of taking control, right? You're naming the person who you want to speak for you. And you know what? In private practice, I saw this quite a bit, where folks say, listen, I don't want to put that burden on spouse. Mama, dad, this adult child has my, or sibling, sister has my trust, and I really want her to speak for me. So I'm not saying that's your choice. I know you just asked me a question, but we do see that. We do see that. I think if you are going to go away from your spouse, in other words, if you're going to name a beloved sister, an elder sister, or mama, as the case may be, you need to communicate that with your spouse. You say, listen, I'm making this choice not because I don't love you, but because I think that this would be the best person to speak calmly, and it doesn't put the burden on you. All right?
Sure. I know what our president said.
Yes.
To me personally, it makes more sense to clarify things by questioning when things are hard.
Yes.
The way she did it, I appreciated it, I understand that. So with that, who we are as a community here, many of us do not have relatives in Delaware.
Okay.
But in today's technological era, for example, my son is around, he's 100 miles away.
Mm-hmm.
Can he, in that case, call Christiana and identify who he is, and then tell them what to do and what not to do?
Okay, so we have, for those who don't have family that here, living locally, can you still pick someone out of town? And the answer is absolutely yes. I shared my story, sort of give you a best case scenario. But if you don't have family here, and you trust a doctor who's a son, that's a beautiful example. And yes, they can call in, and of course your son will come, as he can come to help out. I was giving more of a personal, real-life scenario. But yes, out of town, family, friends can definitely be named.
The hospital accepted.
The hospital accepts, yes.
So the second part of this question, they can authenticate that person over the phone?
Yes, they can.
So my question was something different. You gave a scenario that, Dr. read that both the husband and the wife are incapacitated.
Right.
And you said that the spouse can generally be taken as someone, as a health proxy, without having it be designated through you?
It is true. That is correct. But you don't want to get yourself in that situation.
reason I'm asking that,
Yeah.
if that's generally taken as a legal designation without a document, is it better to designate someone other than the spouse? In the event that both husband and wife come together, you know, or they're in an accident together?
No, good question. The best way to do it is you designate spouse or a primary, who you really want. Generally, it's going to be the spouse, and then you have an alternate.
So there's, okay, because I didn't see in the alternate spot where it's documented, it just says one person.
You can write in alternate.
Thank you.
All right, we're going to take one more, then I'm going to go move on. Yes?
Well, it's only applicable in the state of Delaware, or can it be used? like,
What's that?
The will.
The will. Have we got to the will yet?
No, the
Advanced Healthcare Directive? Good. That's a wonderful question, because that's talking about, it's a concept of law called portability. Portability. And yes, generally, a power of attorney, an Advanced Healthcare Directive, and a will, absolutely, are portable. You make it, if it's effective and legal in one state, generally it is portable to the others, as a rule of thumb. However, what I advise individuals is, we have a number of folks who live in Delaware we call snowbirds. They travel 3 months of the year to Florida or Arizona. I'm very jealous. I can't get out of Ellesmere, and these people are going around the country, okay? We have another group of people, for example, parents, who will go to, I have dear friends, and they visit, they go 6 months to California, and then 3 months to Texas, and then come back here to visit family. If you are making a long stay on a regular basis to a state, like going 3 months every year to California or 3 months to Florida, I strongly recommend that you put a Advanced Healthcare Directive with the state you're going to, California, Florida, language, and a power of attorney in that state as well. So, because you're spending so much time there, if something happens, you have that state's document, you don't get into a fight with the bank, with the hospital, etc. So, you have one here in Delaware, you make an exact replica of that using that state's language, made, signed, notarized, what have you, in that state. The will, that's why I was asking, are you talking about the will? Because the will is portable, absolutely. If you make a will in Delaware, it is good in all 50 states, absolutely. If you make a will in New Jersey, and it was good when you made it in New Jersey, valid under New Jersey law, or you made it in Pennsylvania, it's valid in Pennsylvania, it is absolutely valid here. Okay? Does that answer your question? Great question. Portability. You agree with that, Mr.?
Yes, I do.
Okay, good. All right. Okay. So, the last will and testament. Again, you have a beautiful example that was handed out today, and I compliment the society on a beautiful document. What's the most, we're going to walk through just 3 sections briefly, but what's the most important aspect of this document here today? What's the most important aspect of the will? Who gets what? How your estate is divided up? You seem to have all the answers today, sir. What's that? The executor. Yes, you threw your voice well. You threw your voice well. The executor is the most important part of a will. And I'll explain why. And this is Ciro talking. This is the bureaucrat talking. All right? By the way, 0 properties, remember me? I'm not the most famous Ciro property in Delaware. There is another Ciro property, my father, who's more famous than I. And he has been practicing law for 56 years here in Delaware. He is the patriarch. There are 12 Pompadis who are lawyers, and he is the patriarch of the family. And I'm the youngest of 6. And I said, Dad, you had to wait to 6 children to give me the name, right? And we have a friendly competition. So, by the way, our friend is not here, but it's not Salesian. It's, if you're going to live in Delaware, you need to know the high school Salesian. And my dad, we tease each other because my dad graduated number 2 at Salesianum, but I graduated number 1. He went to Penn. He's always putting that dig into me, but I went to Princeton. He made the rank of captain in the Army, and if the heavens permit, next year I'm going to be a major. So I got that little dig on him. I remind my father, who may be practicing 56 years, but I've been elected twice, on the verge of being elected a 3rd time as a Register of Wills here in Delaware. And my father says, yeah, you may be elected, but when the people walk into the booth and they check the name, they think they're voting for Dad, not you, son.
That's the good one.
Yes, he's right, by the way. When I go out to events and people say, who are you? We want the father. We don't want you, kid. We want where's the father? We thought we were getting the father. Now, I mentioned Dad because my mother has died. Dad is the surviving parent. I have, as I say, 5 brothers and sisters. They all more or less live locally. I'm the youngest. And we all know what Dad's will reads. When Dad dies, my sister Regina, who happens to be the oldest, my sister Regina will be the executor of Dad's will. Sound okay? It's not okay with me. You know why? You know why it's not okay with me? I'm the Register of Wills. Dad, I'm not going to be the executor? Dad, I'm the only child that's the attorney. I'm your law partner. I've opened that door every morning for you for the past 20-some years. I'm not going to be the executor? All right. You can see this keeps me up at night. My dad knows something, and he's a very wise man. And he knows, just as I started today's conversation, that when he dies, my family, my brothers and sisters are going to be grieving. And we, because we're in grief, are going to be angry with each other. We're going to throw elbows at each other. It's natural. It's very natural. We've all been through that. You know, in that first year, especially when you've lost a parent, you say things that aren't you. You do things, and you take a step back and say, is that really me? Did I really do that? And so as a result, my dad knows that we will be fighting. And he picked Regina because Regina is the person, in some regards because she's the oldest, but she's the person that can keep the family on the same reservation. And I have a sister who loves to run off the reservation at a moment's notice. And Regina has the ability to grab her by the collar, as ladies can, and bring her back onto the reservation. In other words, my dad has picked the person who, when we're all grieving, can hold the family together. And Regina will say, when Dad dies, listen, here's Dad's burial wishes according to our faith. Here is the will, and we're going to divide up his things according to the will and our faith. And here's the process which we're going to sell his condo, etc., etc. And even though we're grieving, we won't fight Regina. We'll say, yes, Regina, we respect you, we love you, we will follow your lead. So the most important person in that will is who you're going to name to keep the family together despite the grieving and keep things moving forward. Because, ladies and gentlemen, a little secret about your will and how things work is that you're making it today in 2018, and you may not die for a few years hopefully we're all going to live a long time. And things sometimes change over time. I'll give you a small example. This year we've had 2 wills filed at the Register of Wills that say, until when I die, I want my money to be managed by Wilmington Trust and then dispersed when the estate is closed to my family. Well, Wilmington Trust doesn't exist anymore, right? And so if that would happen in our family, Regina would say, look, Wilmington Trust doesn't exist. At the end of his life, Dad was working with Andy at Wispis, for example, and so I'm going to put the money with Wispis. They'll manage it until we disperse it. Everybody okay? And what are we going to say? Yes, Regina. And if you don't make a will and don't name that executor who can be the person to keep everybody on the reservation, when something happens, okay? And something always happens. Despite all our planning, something always happens. You need an executor who can limit the arguing, who can limit the fighting, and keep everybody on the same reservation. Okay? And if you don't make a will, if you do not make a will, who decides who the executor will be? The law? The state? ISD?
You as the...
I do. What? I do, at law. And you don't want to put that decision in my hands. I'm a good guy. But I don't know who your Regina, I don't know who your key person to keep the family together. And so often, I have to guess. And when we guess, it's not my fault, but problems happen because I'm guessing as to who the person should be named. Okay? Do not put it in my hands. Take control now and name an executor in conjunction with executing your will. The second most important part of the will.
Sir, before you,
Yes.
just a quick one.
Yes.
Can there be more than one and alternate?
Yes. So, good point. So with an executor, you name one, and then you generally name an alternate. That's good practice. Can you name 2 and an alternate? Yes. You're taking control. You can name as many executors as you want and as many alternates. And I like the language. I'm not giving legal advice, but I'm just as a person, I looked at this, and this is standard for other Islamic groups, and I like the language here. It's good language in terms of the naming of the executors. And so I do get the question, well, how many should I name? Can I name 3 executors? I have 3 children. Should I name 3? I generally, and again, this is just information, I generally say, if you have 2 adult children, name them both, right? So you give it to your spouse, and then the alternate might be 2 adult children. Because if you name one over the other, you can use some common sense, right? There's going to be hard feelings. You should, but never have 3. Never have 3 executors, never have 3 alternates. The reason is this. It's tough enough to get 2 people to agree to anything. Well, 3 people are running to my office all the time and say, we can't agree, Cyril, we can't agree. So it's good to have an executor, it's good to have an alternate. If you were my dad and spouse is predeceased, you have 2 adult children, I generally say name 2 adult children. They're going to get along anyway, right?
Not necessarily.
I'm sorry? Not necessarily, but then you have to figure out who can lead. All right. The second critical component of this will, and you probably don't even think much about it. I looked here, and again, this is pretty standard for other documents of its kind that I've seen, is the section on burial arrangements. Burial is so important for people of faith, and that it be followed in accordance with our faith. And what I like, this simultaneously explains burial. And here in Delaware, what controls is what you designate. So you are designating how you want your burial to be. You are taking control now, okay? And by doing so, you're ensuring that your burial will be in line with your faith. Great, I say kudos, okay? Because I see so much fighting over burial. And the family coming to us and say, well, Dad didn't make any decisions. Who gets to decide now? We are arguing. By making your burial in conjunction, your wishes known in conjunction with this will, you are, and in accordance with your faith, you are taking control now, so there won't be any fighting afterward. Okay? And then the third component, of course, that's important with a will, is who will receive your estate. And again, I applaud this document in the sense that it's written in accordance with your faith and in line with your faith, which is so beautiful. It should be celebrated. Okay? And so this ensures that your estate, as it goes through probate and goes to whom you want it to go to, will be in line with your faith. I do note, and we talked about it earlier, that here in Delaware, a will is only valid if you sign it in front of two witnesses. You have to sign in front of two people. Did I say notary? No. It's you're signing in front of two witnesses. And generally those witnesses should be independent. In other words, not a member of your family, not going to inherit under the will. Independent. Okay? And the reason that we have two is that we want to prevent fraud. We don't like the Pennsylvania rules. We in Delaware are trying to prevent fraud. We think that if you have two witnesses, that if someone dies, one witness could forge their name and then put their signature. But if you have two, the conspiracy will eventually break. Two people are trying to forge what happened. That conspiracy will eventually break. Two is the key number. You have to have three signatures. Your signature as the testator and two witnesses. Okay? And I like the fact that this allows for, right here, for two witnesses. Very nice. Okay. I just got a will in this week where it had the testator's signature and then a notary. So the testator signed in front of a notary. Is that a will? No. No, it's not. And the family is in an uproar. How can it not be a will? Dad signed in front of a notary. Because Delaware law says we need what? Two witnesses. The notary's how many witnesses? One. Wow, yes. Hey, that ain't a will. Okay, so we have to have two witnesses. If we do not have a will, who gets what? So if you don't have a will, there's going to be fighting about burial. I guarantee it. If you don't have a will, you haven't taken control to name the executor. It's going to fall in Ciro's lap. I'm not going to do a good job because I'm not God. I can't read your mind or the family's mind. And I'm going to guess, and more than likely it's not going to go well. Okay? So that's the second problem. The third problem is, who gets what? How do we decide who gets what when you don't have a will?
I'm sorry, is probate only applies to insurance?
No. So the question is, does probate only apply to insurance? Just the opposite. Insurance is a private contract generally outside the legal process because it's between the insurance company and the beneficiary. Probate involves everything you own at the time you die, the estate. So, who decides when you don't have a will who gets what? The registered wills, I wish, because I would be writing most of it to myself. I'm just teasing. The law does, and we call that law the intestacy code. when you die without a will, we have to follow the intestacy code. And the intestacy code does not follow your faith. The intestacy code is at complete opposite. I'm not going to go into details now, but it's complete opposite to how your faith dictates. So the fact that you're taking control now to make sure your property, your things are going as your faith dictates is a beautiful step. I applaud it, because if you don't make a will, it's not going to be in line with your faith. Okay? All right. I know I bored everyone here today, yes? All right. I thank you for your time. I'll be happy to take some questions offline. I started my conversation with thanks, and I want to end it by saying thanks as well. And on a much personal level than you can imagine. I told you about the grace that I received when I was here the last time. I will also tell you, besides 8/18/18, it is a special week in my culture, because the 15th of August is a huge holiday for Italians worldwide. Going back to ancient Rome, Caesar Augustus said, "I'm a god, and thereby August will be named after me, and thereby August will be what? The longest month of the year." Did you ever wonder why August should have 30 days, not 31, right, by the calendar, but it has 31 because Caesar Augustus said it must be the longest month of the year. And at the midpoint, we will have a grand celebration. And so we had some of the greatest writers and craftsmen having the great Italian, what we call the Ferragusto. And the reason that I mention that in context of here is that my training is in the humanities. When I went to school, I studied the ancients, and then I went through and studied through the Renaissance. I'm of the classics, literature. And so when I teach humanities today, so often we teach it wrongly. And by that I mean we teach the ancient world, which was the incredible, the genius. And then we have a very myopic view. We teach what's called the Middle Ages. You've heard of that, right? The Dark Ages. But that's a myopic viewpoint, because during the period from ancient world to the Renaissance, it was a dark age in Europe, but what was happening in the Arab world? It was a golden age. Through the Islamic faith, it was a golden time. And then we pick up with the Renaissance. Why the Renaissance? And I teach this, so this is Ciro's viewpoint, not what you would read in a history book. We are still living in an era of the Renaissance. We're still living in a humanistic era of discovery of the Renaissance. But the Renaissance happened why? Because Michelangelo, Brunelleschi, Petrarch, Ficino, Da Vinci were geniuses? Yes, but no. The Renaissance happened because the Islamic world in the Golden Age, kept all of the ancient knowledge. We would not be in the special place that we are today without your culture. My culture flourished because of your culture. We're interdependent. You took from us, and when we lost it, you kept it. And Ficino and Petrarch, what did they do to rekindle the knowledge? They went to the Arab world and said, "Give us back our knowledge. We lost it. You had it. Can we take it back?" And so when I look at civilization today, I take great pride in my heritage, which is the ancient world and the Renaissance, an era we're still living in. But I also know is that we wouldn't be anywhere without your culture, our faiths, our cultures working together. So in this special week, 8/18, who cares about that? This is the Ferragusto week. And in this, our culture is coming together to bring our world under the heavens forward. So with that, I say thank you.
very beautiful, informative information. Thank you so much, Mr. Papri. We appreciate your presence. Having said that, now Sheikh Abdel-Hadi will speak from Sharia perspective.
بسم الله الرحمن الرحيم. الحمد لله والصلاة والسلام على رسول الله وعلى آله وأصحابه ومن اهتدى بهداه. Inshallah, Brother Ijaz and Mr. Seal have covered almost each and every legal aspect of it. And we have now the most important aspect of it, which is from the Sharia point of view or from the Islamic point of view. As we all know, to have wasiyah, the will, is very, very important. It's actually a must in the religion of Allah subhanahu wa ta'ala. The Prophet sallallahu alayhi wa sallam made it clear that he said, ما حق امرئ مسلم له شيء يوصي فيه يبيت ليلتين إلا ووصيته مكتوبة. That it is not permissible for any Muslim who has something to bequest, has something to will, to stay for 2 nights without having his last will and testament written and kept ready with him. It is a must, and the narrator of this hadith is Abdullah ibn Umar radiyallahu anhu. Actually, subhanAllah, if you look at it, it is very important for you because the wasiyah is a form of sadaqah jariyah. If you look at it, you actually benefit from it the most, and also others will benefit from it. Because the Islam gives you the permission to give part of your estate or part of your money in any way you want, in any noble cause, any profit organization, mosque, orphans, shelters. So subhanAllah, people will benefit from that, and at the same time you will benefit even before that, because this is a kind of a form of sadaqah jariyah for you. It's very important to understand this part. So subhanAllah, Allah subhanahu wa ta'ala gives you a chance to even benefit after your death from not only your relatives and the heirs and those who are qualified to inherit from you, but subhanAllah, it can actually go beyond that. Okay. And in Islam, as we all know that the power of the testator is limited in 2 ways. Very important. Number 1, he cannot bequest more than 1/3 of his net estate. So the Sharia of Allah subhanahu wa ta'ala gives you the permission, it is optional, to give 1/3 of whatever you have and to give it away in the sake of Allah subhanahu wa ta'ala. 1/3 of it. Unless, if you want to go more than this, if you want to go more than 1/3, then all the other heirs consent to the bequest, or there are no legal heirs at all, you do not have anyone to inherit from you, or the only legal heir is the spouse who gets his or her share, and that residue can be bequeathed. This is if you want to go more than one, if you want to go more than 1/3. And we all know the hadith of Sa'd ibn Abi Waqqas, when he came to the Prophet ﷺ, he said, I was stricken by an ailment that led me to the verge of my death. And the Prophet ﷺ came to pay me a visit. So I said, O Prophet of Allah, I have much properties, I have a lot of money, and I have only 1 daughter, no heir except my single daughter. Shall I give 2/3 of my property in charity? The Prophet ﷺ said no. He said, then half of it? The Prophet ﷺ said no. He said 1/3 of it? He said yes, though 1/3 is still too much. And he ﷺ said, it is better to leave your offspring wealthy better than leaving them poor and asking others for help. So the Prophet ﷺ in this hadith gave Sa'd ibn Abi Waqqas the permission to bequest 1/3 of his properties for the sake of Allah subhanahu wa ta'ala. So this is number one. Again, if you want to go or give more than this, then you need to get the permission and the consent of those who are qualified to inherit from you. Number two, you cannot make a bequest in favor of any legal heir. Whoever has the right to or qualified to inherit from you should not be included in your wasiyah. Surely that part or that 1/3 must be out of those who inherit. So you cannot, for example, give part of it to your daughter, because Islamically your daughter inherits from you. Your parents cannot be included, your sons. It has to be, as the Prophet ﷺ said, إِنَّ اللَّهَ قَدْ أَعْطَى كُلَّ ذِي حَقٍّ حَقَّهُ فَلَا وَصِيَّةَ لِوَارِثٍ. Allah has appointed for everyone who has a right what is due to him, and no bequest must be made to an heir. No bequest must be made to an heir. It has to be very, very clear, inshaAllah ta'ala, that none of those who are qualified to inherit from you should be a part of your wasiyah, or should be a part of your will. And that definitely that should be, the wasiyah should be implemented after you pay the funeral expenses and your debts and everything, and then after that it must be implemented. Can I give a gift? Yes, you can. You can give a gift to anyone you want, but again, with the permission of your heirs. Can I give one of my sons more than the other? Yes, with the permission of the rest of your sons and daughters. If one of them said no, you can't. And the person who will implement what they call it, the executive, if the wasiyah contains any form of injustice, anything that goes against the religion of Allah subhanahu wa ta'ala, that goes against the sharia of Allah, if it contains any form of injustice, he has that permission to fix that problem, even after your death, without your permission. And the ayah is very clear in the Quran, فَمَنْ خَافَ مِنْ مُوصٍ جَنَفًا أَوْ إِثْمًا فَأَصْلَحَ بَيْنَهُمْ فَلَا إِثْمَ عَلَيْهِ. Because the point is, لَا ضَرَرَ وَلَا ضِرَارَ. There is no harm, nor causing harm. So if the wasiyah contains any form of injustice, then definitely it must be corrected before you implement it. Again, inshaAllah ta'ala, as you can give a gift to any one of your heirs and one of your children during your lifetime, or after your death, you want to give one of them more than the other, it is permissible with the permission or with the consent of the rest of the heirs.
Brother Ravi, can you clarify that again? Because you and I talked about this.
Yes.
And when I remember our discussion, you said the rules apply the same exactly before or after that.
Yes.
Is that correct?
That's correct.
Okay.
That's why if you want to change anything, and then you need to seek the permissions of others. Like for example, An-Nu'man ibn Bashir came to the Prophet ﷺ one day, and he had a piece of land. So he gave it to one of his children, and he brought the contract to the Prophet ﷺ to be a witness. And he ﷺ said, "Do you have any other children?" He said, "Yes." He said, "Then you give each and every one the same." He said, "No." He said, "أَأَشْهَدُ عَلَى الْجَوْرِ?" Do you want me to be witness over something that is haram? Yeah, so the Prophet ﷺ refused to witness over that. And he said, do you like your kids to treat you in the same way? To treat you equally? He said, yes. He said, then go, اتقوا الله وَاعْدِلُوا بَيْنَ أَوْلَادِكُم. He said, go fear God and be just and fair between your kids. So again, so you can do that with the permission of everyone. Even if you have 20 kids, and 18 of them said yes, we agreed to give our brother a gift. One of them said no. One of them said no. You cannot do it. Many people said, but my son, I have two sons, one of them is more obedient than the other. One of them is very obedient, he listens, he takes care of me. The other person on the other side is disobedient. He's not on the right path. If I give him money, I don't know how he can use it. There is no way.
Does this rule apply to living parents and siblings too?
Yeah.
Yes?
Yeah.
Whatever is their share, if we want to change anything, we have to ask permission from all of them?
Yes. Anyone, as we said, anyone by the religion that who's qualified to inherit from you after your death must have a say if you want to change anything. If you want to change anything.
Sheikh, you may mention that who inherits from you, specific people, that because when he says sibling, to my understanding, siblings are not automatically inheriting from you.
No, they're not.
So if you can mention who specifically may.
Yes, it depends because you know the law of inheritance is very deep and very wide, and it depends who's after you. Sometimes, for example, you have no children, you have only your wife, you have no parents.
So by default, to my understanding, is your parents and your children and your spouse.
Yes.
That's by default. And
Yes.
then if none of those exist, then it goes to
Yes, exactly. Then now, yes. So parents, children, and spouses are the most important people, those who will inherit from you. If they're not there, then there are certain rules and laws for others, inshallah. And that's why we said, for example, let's say you have only, as we said, you have only your wife, no parents. And the wife takes 1/4 or 1/8. It depends if you have kids or you don't have kids. In this case, subhanAllah, you can give, you can request more than 1/3. Because you have only one person who inherits from you, which is the wife. So the wife will take 1/4, you still have a lot, more than 1/3. You can even give everything to your wife without requesting anything. It is up to you. But if you have more people to inherit, then only the Sharia gives you the permission to request no more than 1/3 of your property.
Wife can have 100% if the kids agree.
Yes, definitely. 100%.
Can you go over that, not to belabor it, but clarify that 1/3, is that a must while you're living?
It's not a must.
Huh?
No, not a must. It's optional.
1/3 for Islamic cause.
Yes, and it's up to you. This is not
It's not a requirement.
Yes, it is recommended. Because, this is not a must. It's up to you. If you want to give 1/3, that's okay. If you don't, there is no harm whatsoever. There is no sin upon you, but it's a chance that Allah subhanahu wa ta'ala is giving us a way to benefit others, and you will benefit first. People will benefit from you, and this is, as we said, it will act as a form of sadaqah jariyah, continuous charity.
So the rule is not more than 1/3.
Yes, okay, not more than 1/3. And even that 1/3 is optional. Okay? Yes.
Shahadi, real quick, I heard that you said during your lifetime, the gift that you make to your children, it has to be equal. What if, while we have our expenses and I have a child that has more medical expenses or something like that, like today, I spend more on one child than the other. Is it okay for me to give in my lifetime more to one child than the other, or there's no necessity for medical situations and things like that?
No, that is permissible. Yeah, that is permissible. Even, for example, if you have two kids and you go, for example, you go buy a gift for one of them because, for example, he got straight A's in the school and you didn't get anything for the other one. That's okay as a way of encouragement. But when it comes to what you will leave behind, yes, but the things that you give during your life, like this boy something more than the other, this is no problem with this, inshallah. Okay.
Jazakallah khair, Sheikh. So very quickly, we'll go over this document. It's very brief and straight to the point, but just in case someone may have questions. So on page 1, basically, if you look at it, it says your name and where you're residing, date of birth, etc. So that's on page 1, and initial and date on page 1. Page 2 is your spouse's name, your children's name, and then below that is where you name the executor. There you have the option to have multiple executors. You know, if one is not available or he does not want to do it, then the next one would be the person that would make the decisions. So that basically you identify one or more individuals as the executor. And as Mr. Poverty said, that I guess in number 1 you can have more than one name. He suggested or recommended not more than 2, but you can have more than one name in number 1 and then 2, etc. Arbitration. Arbitration is important because in case there is a discrepancy or something, you know, if you want to identify specific individuals to make kind of arbitrate between, you know, there's any arguments, etc. So you can identify specific people. We have put in there the Imam of Islamic Society of Delaware, but you can cross that off and choose somebody else, whatever you prefer. That's not mandatory and basically it's optional. The next one, Article 6, custody of minor children. Similarly, you identify specific individual or individuals who would be the guardian of your minor children. Same thing in there, you have multiple options. You have, you know, you can do one, your spouse, of course, by default, and then other individuals beyond that. Article 7, Article 7 basically states you're dead. You probably would have to have some separate document or some kind of attachment to this that identifies whom you owe money to. So that would be an additional attachment. Then if you have that, basically you would say, okay, I have so-and-so people I owe money or they owe me money, etc. So that's, if you want to identify that. The Article 8, that's where the 1/3 comes in. Article 8 is where you identify the individual or organization to receive 1/3 of your assets, if you so choose to. Again, as Sheikh said, that's optional, not mandatory, but you can choose 1, 2, 3. We have given an option for 3, you know, places where you can choose 5, 10, whatever you choose to do, that will receive 1/3 of your assets after all your debts and everything is paid off. And basically below that, you sign it, date it, and there's 2 witnesses. And mainly every page has an initials, you know, where you need to initial just to make sure. So that's basically it. And the next, that's the will. And the next page is the healthcare proxy, living will. It's straightforward, just identify a specific individual, but if you want to choose more than one, you know, a second person, primary, secondary, etc. Perhaps we didn't put anything in there, but you can choose, you can say primary, perhaps secondary there, sign it. Similarly, there are places for witnesses, 2 witnesses will sign it. And then you can also put, in case of emergency, their contact information, phone number, etc. It also says that you can notarize it, it's optional, you don't have to do it. And anything from page 5 to 11, as just the inheritance guideline based on Sharia. So those are very in-depth, and you can, there's actually a calculator. I think inshallah we'll probably post that in IC website. There's a calculator where you can put your information to have a daughter and a sister or whatever, and it calculates these for you. There's a spreadsheet. So inshallah we'll put that on our website.
Once again, thank you so much everybody for your time. And I just want to, again, this is brilliant documents, excellent. It's been approved by the person who's going to eventually get to see that one. But as a practicing attorney, I strongly advise that you still sit down with an attorney and go through that, because there are lots of things that you need to cover in the will. So you have to go through, do not rely on this document. Yes, for time being is excellent, it's great, because if you have nothing to do, okay, it's good for now, filling the blank part of it. But I would strongly suggest that you sit down with an attorney and go through the entire process, because the calculation is great here, but what happens if you have a newborn child? What happens if your child dies? How do the documents cover that aspect? So you can attach all these guidelines, but the attorney can put the language in there at the time of my death, this is what it should be calculated. So there are also the issues that you need to address, the way it's been drafted. Again, he already approved it, it's okay, but I would strongly suggest that you should go through that. In my office practice, general practice is that we, again, it's not required, you heard, but we strongly recommend to have a notarized, because it's a little extra headache that you have to sign a document in front of two witnesses and then somebody has to notarize this. Two options: go to a local bank, ask your friends to sit in a car and execute this document at your local branch, any bank, Bank of America, any bank. Generally the banks have a notary. So you sign the documents in front of two witnesses, they'll with you in your car, and then sign in front of the bank, they will notarize free for you. It's better to be notarized, not required, but it's a good practice to be notarized, because those two witnesses can forget, they can collude, they can issue, because again, this document is going to represent your wishes when you are underneath, your dead, you're underground. So you want to make sure it's so clear that there is no ambiguity, no issues at all. Those two witnesses dies, I don't know what Delaware law, but in Pennsylvania the notary has to keep the record. When was notarized, where was notarized, how much money charged, who showed up, what ID was used, when the ID expires, and I'm notary in Pennsylvania. When I die, as part of my will, that notary register goes to local registrar's will office. So they can look back, did you show up in a judge's office, was the person really was there or not. So therefore again, I strongly recommend to do that. Again, these things will come up when you sit with an attorney.
Is it a requirement?
It's not a requirement in Pennsylvania either, but in my office practice, we strongly recommend to do
about it after your death.
As a notary, I suppose to hand in the register, yes.
No, is it a law?
No, it is a law. It is a law. We have to hand it in, because how many people showed up, who notarized not, because notary is just a stamp. Somebody else can forge my signatures, and they notarize it. But I have a law. You came at 2:30, what document you signed? Was power of attorney, was living will, health directive, affidavit, anything else. So I have to write it down, and how much money I charge, $2, what ID I use, when it expires, all these things are written there. So when I die, that thing will go to the recorder of fleet office, registrar office, so they can see 30, 50 years later who notarized what. So again, those are the things that I would strongly suggest to do that. Alternative, as you heard, I would strongly suggest have alternative. A cannot do it, or unable to do it, or unwilling to do it. B can do it, B cannot do it, C can do it. As many you can, but it's alternative, not having two people same time. I think Mr. Poppy mentioned not having two same time because of conflict, and having more than one or two or three, that's good practice, you should do that. I think you already clarified, lots of time when I do a project in Pennsylvania, we have issues that Muslims misunderstand this hadith, that there's no wasiyah from Delaware scenes. So people say, oh, I don't need to write it, it's already dictated in Surah Al-Nisa, Surah number 4, verse number 11, everything's there. No, we have to still write it. Yes, we're supposed to get 1/3, 1/6, 1/8, all this is written. But unless this has been written and notarized or signed or witnesses, the registrar of will does not consider who gets what. So you have to still, even as under Islamic calculation, you still have to write it. If you don't want to give 33%, that's what will is in Islamic law, is 33%. The rest under Islamic law is already the government knows, the state knows what to distribute. But we're not living in Islamic law. So therefore you need to write in order to be enforced. So the both part, a lot of time in presentation, a lot of time people say, well, there's already written. So what am I supposed to give? It's already in Quran, why should I write a will? Well, whatever is in Quran, the registrar will doesn't know. So you have to still write the will. So this is a huge misconception. A lot of times people walk away from presentation, it's already in the Quran, why should I write it? Well, until you write it, it's not going to be enforced. So you have to do that one.
So we're saying that it's not enough just to be, it must be distributed according to the Sharia, just a general statement like this?
No, just a general statement. That's, again, you can say in accordance to Sharia law at the time of my death, according to fiqh of Hanafi, Maliki, Shafi, Imamiyya, Shia, you can say that. So that simplifies a lot of issues. Because when we do will in our office, against office practice, not a law, we ask the person which maktab fiqh you belong, you Hanafi, Maliki, Shafi, or Shia. So a lot of times, yes, I'm Shia, for example. So then we have Shia Imam who wants to be designated. So they give person, okay, I want this person to be. So then we have Shia alternative, A, B, C. If A is not alive, B is then B is not C. Sometimes people say, you know what, I want to leave that portion open and I just want to have according to fiqh of Jafri. That's it, at the time of death. Wherever I die, so the mosque will decide at that time. So to save that, that's one way to do it. Alternative ways that we ask people to bring the whole family tree. How many children you have, wife, husband, asset. So then we ask them which school of thought you belong. Okay, we belong Hanafi. So then we give them, well, these are 3 Hanafi scholars. You want to sit down with them, they'll do your calculation and we'll attach the documentation. Or you want us to do, would calculate. But problem with that is that if the child dies and newcomers comes in, they need to keep on updated. So the best way is that according to Sharia law at the time of my death, according to Hanafi school of thought, that makes life simpler because at the time of death your executives know that your fiqh was Hanafi and you want according to Islamic law, and at that time maybe you have 3 more children, or maybe you had 4 and they all died. So no, the executive know that you're Islamic law and you're Hanafi and that's what you want. They can come to your masjid and say, this is the person who did it. Because in Pennsylvania, what I do with masajids, if you want to write a will, you don't come to me, don't ask me. You ask the Imam that you want to have a will. So Imam will have a list, database. So let's say Dr. Naslim wants to have a will, the brother Shafiq wants to have a will. So you just write down the name in your computer, in the masjid database, the board director knows that these 2 people have a will. So I come in, they come to my office, I sit down and write their will. After that, I tell them to write a check to masjid. So they write my fees to masjid. From masjid I get maybe 10%, 20%. The rest of the money goes to masjid. What happens when they die? The salat al-janazah is going to be here in this masjid. So this database will say, sister, let's say, God forbid, I'll give you a long life. Let's say you die. He would tell his wife, listen, I don't know what's in the will, but based on my database, there is a wasiyah. So make sure you look through your paperwork. So that way, another is saying, you already have database. What's in the will, nobody knows. Only I know are his family member. So that way, we have a double tracking. When you wrote a check, you also wrote to the masjid in the will. So family knows what's in there. So that's how we do it. And so in Islamic law-wise, they will come and consult with you. They'll bring the will say according to Hanafi school of thought. And you can sit down with that and this is your calculation.
Can I ask to a question on this? He said that you can have burial according to your faith.
Yes.
So your religion.
Sure.
Now, according to Islamic guidelines, it's a very, very simple burial. There is no casket, nothing, and there are no idea of the funeral homes. Person dies, they give them a wash at home, just simple cloth, they put them in, and they take them to the graveyard. Can something like that be done in Delaware?
Good question. So, let's look on what this says.
It says not just unless required by applicable law.
But I'm asking, because by encouraging, by pushing the states, the counties, gradually people are getting those things changed. There are some massages that have started having their own simple funeral, bathing places.
Understood. The question that I have to look, and I'm not certain on, is the actual burial without a coffin, right? I will double check that. I think in Delaware it is required, but I will double check that.
For example, in Houston, they got it changed.
I know what you're driving at, that it's not really a question about the burial rites, it's about a political question. Should we be organizing to change the law to accommodate our faith? And it's a question I'd be delighted to, I can look at and do a little more research from my end, and be delighted to have a conversation with the society about pursuing.
Thanks a lot.
Okay, thank you.
Just one more point about the 1/3. Just for your information, inshallah, for the 1/3, that can be given to anyone. Can be given to individuals, organizations, Muslims, non-Muslims. That 1/3 can be given to anyone. Just to make this clear, because I remember that last time that the 1/3 should be just given to Muslims or only Islamic organizations, any noble cause. Any noble cause, and that also 1/3 can be given to, for example, parents if they're not Muslims, friends, non-Muslim relatives. So that 1/3, Allah subhanahu wa ta'ala gives you the freedom to give it in any way you want, inshallah. Okay?
With that, the follow-up question for you is that what happens if your child becomes non-Muslim?
He does not inherit from you. Yes.
Like,
That's it. I think that's it. According to Islam, it's actually both. Very good. I'm glad that Brother does that. Yes, according to Islam, Muslims do not inherit from non-Muslims, non-Muslims do not inherit from Muslims. But again, you can give them gifts. Very simple. For example, if you have non-Muslim parents, your mom and dad, they do not inherit from you, but can you write something to them? Yes, you can.
But the total cannot be more than 1/3 of it.
Yes, yes. You can give them the 1/3, the whole 1/3 to your parents if you want. You can give them gifts during your lifetime. But again, when you die, then those who will inherit from you are those who are qualified only by the religion to inherit from you.
In lifetime, you can give any amount?
Yes.
Even more than 1/3?
Yeah, in lifetime is different. During your lifetime is different, but in a way that, in a reasonable manner. Yes, without causing harm.
the question for you is for 401k, because you mentioned insurance beneficiary, but 401k, the retirements, does this supersede that, or those documents supersede?
So, I can give you from the civil viewpoint, and then we must put it within the faith. So within the civil viewpoint, again, we must apply it to the faith, but within the civil viewpoint, any payable on death fall outside of the scope of the will. So payable on death is anything at your death, the financial institution pays directly to a beneficiary. The most common is insurance. There are, because of the sophisticated nature of financial institutions today, we see some 401ks or Roth IRAs or IRAs or other financial programs which are, some are payable on death, and those would go directly to the person named, and some are not. And to those that are not, they fall within the scope of your estate. The question, and it's outside of my jurisdiction, is in terms of insurance and payable on death, how should that follow the faith law? That's beyond me. But in terms of payable on death, go right to the person and are beyond the scope of your estate, because you don't hold them at the date of death. Remember, your estate is what you have on you at the date of death. Payable on death, like insurance, you don't own at the day of death. They automatically pass to that person. Another common form of payable on death is a joint account. If you have a joint account with right of survivorship, you don't own that at the date of death. At the moment of death, it passes to the person that you own. Again, I'm saying this, that's the civil viewpoint. We must apply it to our faith.
Mr. Poverty, is there anything where beneficiaries don't apply? I cannot think about any financial arrangement where they don't ask you to write beneficiaries.
There are a number of pension programs and retirement accounts that do not have beneficiaries. And what happens is generally, and I don't mean to prolong this, but what happens generally is that there are large retirement accounts out there that are not beneficiaries. They don't pass at the moment of death. They are part of your estate, and what happens is, instead of dispersing them through the will, in other words, giving cash, the financial institution will divide up the monies to the persons who are to receive it under the will, okay? And they are not dispersed, because when you disperse a retirement account, you have to pay taxes. So what the term is, they're rolled over. So under a will, let's say, I'll just say one person just to simplify. I have a financial account. It's not payable on death. It follows the will, and for simplicity here, one person is going to inherit, okay? The financial institution will roll it into that person's name. They won't generally disperse it. When you disperse, there's tax consequences. By rolling it over, the person who receives it takes charge of it, under the will, takes charge of it, and then when that person, the beneficiary, eventually disperses, are the tax implications. So there are many retirement accounts that are not payable on death. And there are benefits, and the reason that the person putting the money aside gets the benefit now. And then, so some people say, yes, I need the benefit now. My heirs can worry about the taxes down the road. But there are many situations where there are.
So at that point, those heirs will have to open accounts to get it rolled over?
They will. A lot of times when it rolls over, let's say, I'll just take two names. Let's say TD Bank and WISFIS. Let's say you had a retirement account with TD Bank, and you bank with WISFIS, or they're your money manager. TD Bank will roll it over to WISFIS. Yeah, you're not obligated to stay with TD Bank. They will roll it over.
Thank you so much. I actually have two questions. One question for Mr. Property. A follow-up. If we have a 401k, as Dr. Han mentioned, a 401k, generally they ask you for this designating a beneficiary, either 1, 10, or whatever you may do.
Right.
But you may not do it in according to your will. You may just put one person. Does that indicate, at the time of your death, now does that 401k come to your estate and follow your will, or would they follow what you have designated initially?
That's the rub of that's the rub. If you have a payable on death, any sort of payable on death, insurance, 401k, whatever, and it's payable on death, it only goes to the beneficiary.
So
if it's not payable on death, it becomes, you own it at the date of death, it's part of your estate, and it passes in accordance with your will.
Thank you so much. And a question for Sheikh. You mentioned that, so for you, I want to make it broader so everyone understands, and for my clarification as well. If I want to give a house, I have 10 houses, whatever. I have 5 houses. But during my lifetime, now, whenever, I want to give my son or my wife or anyone, one of my heirs, that one of the house, but not to everyone. Am I allowed to do that?
Anyone who's qualified, anyone who's qualified to inherit from you after your death, wife, children, parents, you cannot give to anyone anything during your life without the permission of the recipients.
So even when I'm young, I mean...
This is what exactly happened with Abdel-Hadi machine. Yes, when he came and he wanted to give a piece of land for his children, and the Prophet ﷺ refused to witness, to be a witness to that contract, because he only favored one of his children over the others. And the same applies to you.
Brother Hadi, a follow-up question.
Yeah.
Do all the schools of thought, Shafi, Imami, and everyone, they say the same thing on that?
Okay, it's a good question, Dr. Salim. Not everyone, not everyone. Most of them agree when it comes to the children, because gifting some of them or favoring some of them during your lifetime over others may cause a lot of tension between them later on. So the ulama said this does not apply to a spouse or wife, because your wife is their lover. So really gifting her anything will not cause that much tension as it will happen between the sons. Yes, there are some differences of opinion, but especially when it comes to the children, it's a kind of agreed upon. Okay, parents and the wife are different, and I agree that the opinion that parents can be gifted during your lifetime, and your wife can be gifted with anything during your lifetime, but not the children, when some of them over others. Okay.
It is a practical issue, and we, again, from my experience, what the Imam said is correct, but from my experience, we have issues that we've been dealing, and it's been litigated, I believe, in Georgia State, all the way to Supreme Court. Because according to son-in-law, correct me if I'm wrong, the daughter gets what? 33%, the son gets 67%. The two daughter litigated $40 million estate for doctor and said this is not fair. So this is something you need to sit with your children, discuss that, you get their consent now, and then you can. It's called advancement in legal terms, and you can give a gift now. So what you can do is you can give a daughter 20% now, so she becomes 50, and the son is 50, so by the time the son gets automatically 50. So this is something you need to negotiate, discuss now. There is a difference of opinion among scholars. At the end of the day, the essence is that you want your family unity. You do not want family to fight. So if you discuss this now properly, the family is not going to fight. So yes, there is a difference of opinion. But this is a practical problem out there. It's been litigated. It will be litigated. It's not full-blown law yet. Because on its face, it looks very unfair. But practically, it's not unfair because the daughter is supposed to inherit from husband, brother, father. So in reality, she gets both. So this is something we need to discuss, and there's a huge difference of opinion among scholars.
And actually, in some cases, that you have a daughter can take 1/2 of your property. And $2 if you have can take 2/3. It depends how many people, how many sons and daughters you have. It's yes, as you said.
Can you clarify that again? I have heard both opinions. One is that the share of the daughters, even if they are 5, it would be 1/3 of the total. And the other say between the boys and the girls, it will be divided half and half, and then. Further, can you elaborate how exactly it works?
Because, if you have, for example, let's see, in some cases you have sons and daughters, or sons only, or daughters only, okay? So this is, yes, we're not talking about the parents now, just we have sons and daughters, or you have sons only, males or females. So like, for example, if you have only one daughter, she gets a half. She gets a half of everything you have. And if you want to bequest something, you can do that. If you don't want to bequest anything, you can give that everything to your daughter. But Islamically, she gets 50%. if you have only one daughter. If you have two, they get 2/3. Can you imagine? They get 2/3, and the rest, the other one, the last third can be given in any noble cause. And if you have sons and daughters, now they are brothers and sisters, then as Allah said, فَلِلذَّكَرِ مِثْلُ حَظِّ الْأُنثَيَيْنِ. Then the boy gets twice as the brother. So it depends again who is there at the time of death.
If there are 2 boys and 1 girl, then how would you distribute?
Okay, okay. Yes.
Table. I think you have to refer to the table.
Yeah.
Because it's very complicated. If you refer to the table, there's just so much calculation comes into it.
Just on that note,
I'm sorry, I have to head out. So if you have any question for me, please shoot it out. Otherwise, Imam's here, alhamdulillah, give him long life. And so is he. So you can ask them a question later on, and I think we should go offline because these questions are getting into personal nature, as I mentioned earlier.
We'll edit it.
You have to hypothesize. So either you go offline or hypothesize because it's getting personal level, so ethical issues will be there. But anybody has a question for me, I'm willing to answer. Oh, you have? Okay.
I have a question, follow-up question to what you just mentioned, that this issue has been litigated. So if I'm already saying this, that this is what I want my daughter to get, and this is what I want my son to get, why is there litigation beyond that? If in the will I say, okay, whatever the Quran or whatever the law of Allah subhanahu wa ta'ala says that my daughter should get this amount, whatever it be, and my son should get this, and this is my will, and I sign it and I authorize that, why is that even being litigated beyond that? Because that's my vision will, and that's my asset.
That's a very good question. Correct me if I'm wrong. The Prophet ﷺ said that my ummah sitna is mal, so the wealth. So we are talking about $14 billion, and doctor died, and the son is getting like 67% of that. He hasn't done anything extraordinary. The daughters have the same education. Matter of fact, one of them had more education than son, and all of a sudden they just slashed in half. So that on his face looked very unfair. So that's why it was litigated, that it was not properly done. There was only one son, he was so close to dad, and he just kind of sort of convinced the dad the way it was done. In reality, the dad would have consulted with us, we all should have got equal, we all have same debts, we have all same education. So this son has, or brother has more influence on dad, and that's why dad gave it to him. In reality, that was not his intention. Again, the dad would have sat with the family, with an attorney, with an imam, consulted that, give some advancement in advance. In his life, things would have been different. It was just well written, and after that died, then the distribution of $40 million was an issue. That could have been resolved if family would have sat down, discussed it, with the imam, with the lawyer. I don't think that issue would have raised. It was just later on after his death, $40 million. So it was $40 million question.
Thank you so much. We really appreciate your presence.
You don't have a question for me, right?
Yeah, just on that. So you're saying even after we sign, it can be challenged in court.
Anything in life will be challenged so long we have lawyers alive. So let me tell you, they're going to stick around for a long time. 80% of congressmen or congresswomen are lawyers. So when they lose the election, they come back to practice. So things are going to get litigated. It doesn't matter what you write there. So that's why I'm saying again and again, you need to sit down with a lawyer. I cannot sit down with you. It does not benefit me financially or monetarily, nothing. Why I'm emphasizing? I don't think you can prepare your bill either, because they have conflict of interest. So we, both attorney here, cannot help you. My not being licensed here, he has conflict of interest. But we both are emphasizing that you need to sit down with a lawyer, because these things will be litigated, and they are being litigated. Law for Muslims is evolving right now. Every aspect of Muslim law is evolving. Question was asked about the grave. There are lots of graveyards. I have led the Salat al-Janazah of several different graveyards of several people. There's a different in each locality. You bury in a casket, without casket, there's a stone wall, things like that. It's been evolving right now. So things are going to get litigated. Again, sit down with the lawyer. So whatever you have in your hands, excellent. But do not rely on it until the lawyer does okay. Because they will be litigated.
So brother, that's the question. So we're saying, by law, for example, if I refuse to accept my father's will, I know Islamically, as long as the will does not contain any Islamically, we have to submit and take it as it is. But by law, since we live here in the US, can I choose, for example, to refuse to take this will and take it to the court? Even if I have the witnesses and everything?
No, if the will is properly done, obviously, because there is, again, in Delaware law, I don't know what the law is, but in Pennsylvania, there's 8 different ways that you can challenge the will. Undue influence, that son was so close to dad, he was managing business day to day. He was traveling with dad abroad. We have no idea what influenced dad. He knew more about finance, we didn't know. So all those things. So even the documents itself was correctly executed. Everything was good because the court did not say something wrong with the will. There were 2 witnesses, there was no trial, everything was fine. But the way undue influence happened behind the scene, that's what gets litigation. And those 8 challenges under Pennsylvania law, if I'm drafting it, that's where I'm going to start working. I'm working backward. You're sitting with me, but I'm not thinking that you're with me. I'm looking 4 days from now, you were dead.